Welcome back. Thank you all for coming back. We are right on time. It may be the first time in my life to be at a conference where we are actually on schedule, so we can celebrate that. It's my pleasure to introduce to you Douglas Baird, who is the Harry A. Bigelow Distinguished Service Professor at the University of Chicago Law School. He is a graduate of Stanford Law School. He was the managing editor of the Stanford Law Review. He clerked for Judge Shirley Hufstedler and Judge Dorothy Nelson on the Ninth Circuit before coming into teaching. He has also served as the dean of the law school from 1994 to 1999, which, believe it or not, is longer than the average tenure these days for a law school dean. So he has a very also provocative and interesting topic, the Holmesian bad man and common law contracts. This is a topic that is gaining a lot of buzz right now, again, because of some of the pushback from contract scholars on efficient breach theory. So I look forward and hope you will join me in welcoming Douglas Baird.
Thank you, and I also want to thank the Law Review here for really the splendid hospitality and conference they've organized. And most of all, it's a great privilege to speak at a conference honoring Richard Epstein, a man whose only discernible lapse of judgment was giving me my first job teaching when I was 26, 6 months out of law school and unemployed. What I admire most in Richard's work is his commitment to the idea that a coherent understanding of the law must come from first principles. Simply cataloging legal rules or making vague generalizations is not the same thing as giving a coherent account of the law. As Lord Kelvin reminded us, there are only two kinds of science, physics and stamp collecting. Richard is many things, but he's no stamp collector. And it is in this spirit that I want to revisit Holmes's path of the law. In the winter of 1897, Oliver Wendell Holmes Jr. was 55 years old and languishing in relative obscurity as an associate justice on the Supreme Judicial Court of Massachusetts. He seemed at this time to be destined to remain forever in the shadow of his father, the well-known man of letters who had died only a few years before. He was invited to give a talk at Boston University, and having little to lose, he chose to be provocative. He told this group of law students and young lawyers that if you want to know the law and nothing else, you must look at it as a bad man who cares only for the material consequences which such knowledge enables him to predict, not as a good one who finds his reasons for conduct, whether inside the law or outside of it, in the vaguer sanctions of conscience. Now, many have taken Holmes to task for this bloodless and detached view of the law. Even before the path of the law, a novelist savaged Holmes on this account. Only thinly disguised, Holmes appears as someone called the young astronomer. This character is mocked for devoting all of his time to observing the heavens, separating himself from all human interaction. Holmes, as fictionalized, was someone given to looking at life as at a solemn show where he is only a spectator. Of course, you're not cold, distant, and unfeeling merely because some writer paints you this way. But when the writer in question is your own father, you might wonder if there's not something to it. And one might also add remoteness and an absence of moral understanding do seem recipes for bad judging. Judges should not be distant spectators. When they are distant spectators, they are wont to err and display a heartlessness incompatible with notions of fundamental justice. Such individuals are all too likely to conclude that 3 generations of imbeciles are enough. Now, many have been equally critical of what comes next in the path of the law, the observation that the duty to keep a contract at common law means a prediction you must pay damages if you do not keep it. Here again, something important seems to be missing. Most people think that when you make a promise, you should keep it, independent of the legal consequences. Breaking a promise and then paying damages is not the same thing as keeping a promise in the first place. Now, today, I want to suggest that this critique of the path of the law misses what Holmes was about. And I want to begin with some largely neglected background. Holmes was not speaking in a vacuum. Indeed, his comments grew out of an ongoing debate he was having through correspondence with another scholar. This young scholar was a man named Edward Avery Harriman. He was a graduate of Boston University, at this time a professor teaching at Northwestern. He had just published the opening chapter of his book on contracts entitled The Nature of Contractual Obligation in the Northwestern Law Review, and in this chapter, Harriman pronounced that what he sought was a scientific system of jurisprudence. And as he put it, this requires an analysis and collection of the basic principles of Anglo-American law, notwithstanding the fact that it grows out strangely of this writ system and this artificial division between law and equity. As Harrison put it, depending on these categories to make sense of the law was, quote, about as satisfactory as a method of classification to the student of jurisprudence as the classification of flowers or rocks by their color would be to the botanist or the geologist. So what Harriman did was he set out an objective theory of contract that drew heavily on what Holmes himself had done in the common law. And he sent a copy of this essay to Holmes, and Holmes, by and large, liked what he saw. Harriman's objective, hard-edged, unsentimental, scientific look at the law was exactly Holmes's cup of tea. But Holmes was bothered by the way in which Harriman ended his essay. Harriman ended with the following observation: whether a person who makes a contract is bound to perform it, or whether he simply assumes the risk of having to pay damages, is an important question which will be discussed hereafter in connection with the subject of remedies for breach of contract. Okay, so he says this is an important question. The difficulty, of course, is that for Holmes, this important question had an answer. He had already observed before, this is Holmes speaking, it's obvious that the main consequences attached by the law of contract is a greater or lesser possibility of having to pay money. In his letter, Holmes urged Harriman to adopt this view of the law in his chapter on remedies. And again, quoting from the letter that again appeared before the path of the law, that will strike you as being a little bit familiar. The liability to pay is the consequence attached by the law to his act. When he commits a tort, the liability is absolute. When he commits a contract, the liability is defeasible for the happening of an event. A contract at common law is nothing but a conditional liability to pay damages defeasible by performance. Now, to understand what Holmes is saying here, you must remember the context, and you must also bear in mind what Holmes believed to be the testing hypothetical. Right, let me give you the testing hypothetical. Our neighbor plans on having a big party on Saturday afternoon outside. He wants two things. He wants his lawn to look great, and he wants to buy insurance in case bad weather forces him to reschedule. As a result, I promise to mow his lawn for $10, and you promise in exchange for $10 to cover his losses in the event the weather isn't good. There are two variations to consider. First, I break my promise to mow the lawn. Second, it rains. How do we think about these two cases? Now, for purposes of everyday life, the two are not at all the same. I broke my promise, you provided insurance. But for Holmes, there is nothing from the judge's perspective that distinguished the two cases. In both, our neighbor can come to court and force each of us to pay a compensatory sum. For the judge, it's a matter of complete indifference why I broke my promise or why the sun didn't shine. The statement that one who makes a promise must pay money to our neighbor if the promised event, a mowed lawn or good weather, fails to come to pass, encompasses my obligation and your obligation equally well. As far as the law is concerned, we both committed ourselves to paying a compensatory sum conditional on a particular state of the world when we made our promises. That ordinary people think the two promises are different is quite beside the point. We're trying to identify fundamental legal principles. There is one force behind electricity and magnetism. It doesn't matter that in our everyday lives the two look different from each other. The same is true here. Holmes believed that he provided the simplest account of what it meant to say a promise was legally enforceable. It was to be preferred over others precisely because it was simple. Injecting other notions did no work. In the words of pragmatist philosophers Charles Saunders Peirce and William James, they have no cash value. If they're of no help in describing the pattern of decided cases, they should not be included in an account of first principles. Occam's razor is useful in law as elsewhere. Okay. Again, this is where context matters. Harriman rejected Holmes' assertion that the promise of good weather and the promise to mow the lawn are the same. Okay. In his view, a legally enforceable promise contained both a primary obligation to keep the promise and a secondary obligation, such as the payment of damages if someone failed to keep the primary obligation. Now, of course, in some cases, and this is the insurance case, the primary obligation and secondary obligations correspond with each other. In the case of the promise of good weather, again quoting, the primary obligation to compensate the other party for the non-occurrence of the promised event is necessarily coincident with the secondary or sanctioning obligation to pay damages for breach of contract. But in other cases, the two do not correspond. When I promise to mow my neighbor's lawn, there is the primary obligation, my obligation to mow the lawn, and a secondary obligation to pay damages if I fail to do so. Again, as Harriman explained, quote, every breach of contract gives rise to a secondary obligation to pay damages. But in contracts where the promised thing is within the control of the promisor, there is in addition a distinct primary obligation to perform the contract. Now, from Holmes's perspective, Harriman's account was flawed, not because it was wrong, but because it injected a concept, the distinction between primary and secondary obligations, that did no work. Holmes and Harriman, and this is what's crucial sort of understanding the bad man concept here. Holmes and Harriman were both pragmatists who both shared an objective view of the law. Both were in search of general principles that would give an account of the law analogous to the account that scientists gave of the world around them. Neither was interested in law and morals. The use of the bad man was simply one way, among others, that Holmes tried to persuade Harriman that he was wrong to posit primary and secondary obligations. Harriman's account did not have too many morals. It had too many moving parts. Now, what comes next is Harriman's, and this is after The Path of Law was published, in which, if you recall in this passage, he explicitly in the text refers to Harriman. It's something that's forgotten because most people don't know who Harriman is. But after The Path of the Law came out, Harriman responded to Holmes's criticism. And as best I can tell, this has been forgotten. And he responded in the following way. For starters, Holmes's account of contract remedies is limited to the common law. For Harriman, this is completely contrary to the spirit of the pragmatist enterprise. Ignoring what happened in front of the chancellor was a mistake. No botanist would claim to have a theory if it applied only to flowers that were yellow. Moreover, even with respect to common law courts, Holmes neglected centuries of history. As Pollock and Maitland had pointed out, quote, the oldest actions of the common law aim for the most part not at damages, but at what we call specific relief. And finally, and most significantly, Harriman goes on to show that distinguishing between primary and secondary obligations does have explanatory power. And this is the case he used. An architect refuses to turn over his plans unless the brewery agrees to buy refrigerating equipment from him. We have an architect, the architect has made plans for a brewery, and at the last minute says, I'm not going to turn over my plans unless you promise to buy refrigerating equipment from me. And the brewery needs to get the brewery built, and ultimately what they do is they promise to pay the architect more for the plans than they have originally intended. The architect goes and tries to collect the higher fee, the brewery refuses, and then the architect sues. Okay. Now, by Holmes's account of contract law, one in which the promisor has a choice between paying for damage, between performing or paying damages, it would seem that the promise to pay the increased fee should be enforceable. The architect can choose, under Holmes's account, between performing or paying damages. Hence, a new deal in which the architect gives up one of his options, his option to not perform in return for a higher fee, is supported by consideration. In other words, there is a bargain, and I'm the architect, and I have an option to be the Holmesian bad man and not perform, and I'm giving up that option. When I give up that option, I'm giving something in return for the higher fee. But of course, the law is otherwise here. A promise to pay more for something already contracted for is not supported by consideration. Compare that with Harriman's theory. Harriman can explain such cases with relative ease. The architect's obligation to pay damages when he breaks his promise is merely a secondary consequence of the primary obligation to keep the promise. The damage remedy is the way the law happens to enforce the primary obligation, but it's distinguishable from the primary obligation itself. Because the underlying obligation exists independent of the legal remedy, the promisor doesn't have the option simply to not perform and pay damages. Hence, the architect gives no new consideration when he reiterates the promise to perform. That promise to perform, that primary obligation, always existed. This example shows how positing an underlying primary obligation does work independent of the sanction associated with the violation of the right. Let me suggest another place where Harriman's theory of primary and secondary obligations is useful. And this is at the intersection of tort and contract. And while it does not loom large in terms of decided cases, in the search for fundamental principles, the question is not whether a phenomenon is big, but rather whether it reveals something interesting. The facts are from Lumley versus Wagner and Lumley versus Guy. You hire me to sing at your opera house. Another impresario at a much bigger opera house learns of the contract between the two of us, and he comes to me and says, "Look, Douglas, this will be your big break. Breach your contract, pay the person compensatory damages, and come to sing at my opera house." Okay. Now, in Holmes's world, the rival impresario has done nothing to which a judge need pay attention. He has merely persuaded me to exercise an option, my option to pay you compensatory damages and not perform, and put my skills to better use. Okay. He's done nothing wrong. He has just persuaded me to exercise one of two options that I have. But in our world, the law, again, is different. We have quite a different result. You have an action not simply against me for failing to sing, but you also have an action against the rival impresario. Okay. Now, how can that be? Well, again, in Harriman's scheme, your action against the rival impresario exists because behind my obligation to pay damages, there was a primary obligation that you were entitled to. The law protects this entitlement that you had, not only through the damage action you have against me, but against your right to bring an injunction against the impresario, the person who induced the breach and who is on notice of it. Now, this suggests, I would argue, a radical Epsteinian-inspired reformulation of Harriman's theory of contract that strengthens it. One of the problems of Harriman is he, relative to Holmes and Epstein, is an intellectual midget, and so I'm going to need to do some work to make him hum. And here, what I want to do, and what I will do in the essay, is draw liberally on one of my favorite Epstein papers, and this is the one that connects third-party liability in Lumley versus Guy with the problem of ostensible ownership. Okay, so this is the way the reformulation goes. To understand what a judge does in contract cases, know that behind every legally enforceable promise is a primary obligation to keep the promise. Associated with this primary obligation, this entitlement, are the remedies that the law attaches to the failure to keep the promise. Okay. And the remedy, in the first instance, is a right to specific performance. The damages remedy is supplementary. Circumstances may often arise in which the primary remedy is called off, but the damages remedy is supplementary nevertheless. It does not reflect true principles. So, again, this is a view of contract law that is sort of the opposite of what you're taught in first-year contracts. Okay? It's the idea that we have a primary obligation. There are secondary ways in which that obligation is vindicated. Among those secondary ways, the primary one is specific performance. Why? Because this primary obligation is property-based. Now, in terms of litigated cases, we see damages actions all the time. But the reason we have the damage actions are for perfectly pragmatic reasons, not ones that derive from first principles. Holmes's mistake, in other words, was imagining that the damage remedy was fundamental rather than it was an accommodation to practical considerations. The contractual obligation to perform is at its heart a property rule. While the property-like nature of the rule is beneath the surface, it exists nevertheless. Okay. To show this, return to tortious interference. This tort exists even when there is defense, such as one based on the statute of frauds, on the underlying cause of action. Why? Because there is a primary obligation, my promise to perform at your opera house, that is behind this damages action. Merely because the damages action is unenforceable doesn't mean that primary obligation doesn't exist, and it doesn't mean that it can't generate a cause of action on your part against the impresario. To continue with the tort of tortious interference, one can enjoin a third party from interfering with the contract, even if the promisee is entitled only to money damages. So, in other words, even in a situation where you can't bring equitable relief against me and force me to sing, you can bring equitable relief against the party who's interfering with you, which is again odd if you rely simply on the Holmesian account. Another way in which it's different, restitution damages are available to capture the gains that arise by virtue of tortious interference, even if they're greater than expectation damages. In other words, if you lose $10 because I don't sing at your opera house, and he gains $100 when I sing there, your cause of action against him is not merely for the $10 you lost, but rather for the added benefit he got. These are all property rules, not liability rules, and they all depend upon the existence of a primary obligation. They stand apart from the merely secondary obligation to pay damages, and all these things are completely inconsistent with Holmes's conception of contract. Holmes's conception of contract cannot explain what's going on here, but a property-focused theory of primary and secondary obligations can. So, where does this leave us? Well, it leaves us with a question, one which I'm actually interested in hearing Richard's answer to. It's, how much do we make of all this? And I think you can take two different points of view. Defenders of Holmes can point out that tortious interference is a minor and late arrival that lives at the periphery of contract law. That Holmes's basic principle does not capture it is of little moment. As our late colleague Walter Blum would often want to say, in law, as in life, 95% is perfection. So the fact that Holmes couldn't describe every single case is not of great consequence. That's on the one hand. On the other hand, you can take a different view. That view would be that it's exactly at the periphery that we can see the difference between crude categories and fundamental principles. It's exactly here where theory has its explanatory power. A property-based conception of contract may be what is needed. In all events, it's this need to confront fundamental principles in this fashion that I think characterizes and epitomizes the very best of Richard Epstein's work and what makes it so formidable. Again, there is a fundamental difference between physics and stamp collecting. So Richard, I want to hear. Oh, you agree with me? This is good. I'm waiting. Yeah, this is so good. Oh, no, I have, in the essay I've got that. Yeah, and people anything else. Trustees, you have to do a contract with yourself. And it turns out you look at the data in school, and you realize they're only $1,000 with. Are you as a trustee use grounds for that research? No. And the answer is no, right? You are not required. You do not want to undermine. Last bit on this. You have a situation where an inadvertent will have to sit down and work with the mission. That would mean you have somebody to engage in. All this is selling out hundreds of actually pulling out the road to the future. And, you know, it's far from saying, aha, you're a wonderful person, you managed to get things a higher value by something I heard, maybe I heard. But as soon as you go and yes, but again, that's not a knock against what Holmes is doing. Remember, because Holmes is simply, saying, what happens on the outside, or how people regard the law, or whether people feel morally bound by the law. It's not what I'm about. I'm just trying to describe what it is the judge is doing, and the judge isn't involved in throwing people out of the trade association. That's not directly. Hold on, let me. Right. Well, yeah, but that turns on the existence of these. Yeah. Yeah. Right.
Well, I have another thing to I think the two areas that you draw on and then, first there at the atmosphere itself. And I think the indeterminacy of the atmosphere plays some of the role that this is. And you can't know when you're sitting there figuring out whether to breach or not, what damages will be, and how high is the risk that foolishness or inefficiency in the law. I think it's part of the hard wiring to make it difficult. Look at all at damage theory as a motivating force behind at the time.
Yeah, well, I think any account of homes nowadays looks at its reception by its era, which is Richard Posner, and Posner's conception of efficient breach. I don't know where to start. I think you can give a coherent account of expectation damages that suggests why it's not crazy to have expectation damages, in the sense that you do have this effect of at least in theory forcing people to internalize the cost of their conduct. And you can explain that as an aspiration, but the difficulty is that it's hard to know why you should do that as opposed to doing a number of other things. And I think the flaw in Posner's approach and Holmes's approach here, I think, is analogous to the one that I think Richard uncovered in Posner's tort work in these great debates they had a long time ago, where what Richard was what Richard was doing was, and again I think it's in the spirit of Harriman on Holmes with respect to contract, was Epstein on Posner with respect to the law of torts, is that Epstein said Posner looks at negligence, but that's not what's fundamental. The same way Harriman said Holmes is looking at damages, but that's not what's fundamental. And Epstein says with respect to torts, the reason that Posner has it wrong is, first of all, for the 19th century, where this is Holmes saying damages where Harriman says damages is a later rival in the fundamental common law rule of civil relief. Epstein says, well, negligence is a relatively later rival in the scene. The fundamental rule is strict liability. And the same way that Harriman said there really are these fundamental forces here, these primary obligations that really matter, Epstein said there are these primary fundamental ideas in the law of torts of force and fraud, and those generate the liability. And what I'm most intrigued by the conception of Holmes and efficient breach theory is not so much efficient breach theory per se, which I think sort of silly as an account of what is, he's taking Holmes to the next level, but yeah, I did say it was silly. But anyway, but what I find interesting, just in terms of the move, is the way in which the texture of the Harriman Holmes debate has the same texture as the Posner Epstein debate in the law of torts. There's someone in the back has a question. Yes.
Oh, I just wanted to actually address two of it, and I read your about
Right. Okay.
What goes on in the ground.
Oh.
So, the reality is, or any of that these cases don't come because of all the informal social norms that are holding all of this together. So I guess I just want a little bit more of your reflections on that's the case prior on or first, the primary or secondary principle. But the reality is that most of this happens outside of the law.
Right.
And that a lot of restitutional norms are holding.
Oh, no, absolutely. And again, I think the the earliest booster of Lisa Bernstein is hands down Richard Epstein, who actually published one of her articles in the Journal of Legal Studies when she was still a law student. The Diamond Card, yeah, but she wrote that as a third-year law student. He agreed to publish it in the Journal of Legal Studies when she was still a law student. And again, I'm also a long time, not as long time, but a long time fan of Lisa Bernstein. And I completely agree that reputation matters and so forth. And to some extent, this paper and this essay is a little bit extremely old-fashioned. It is an essay that is looking at the law as a small and closed system. And I think in confession and avoidance, I think I would say that if this were the only kind of stuff I did, I would sort of agree with you that, Douglas, get a life, do more stuff. But I understand. But I know I am I'm quite aware that this particular kind of exercise where I'm looking at the subject of the paper is the legal history, and I'm looking at historically at how Holmes thought about this stuff and it shouldn't be that shocking, right? You've got two late 19th century contract scholars.
One other point that I want to make is the way I want to think about these contracts that are allowed to apply. At point, if you get on a point on it, president was those so the real hours is there, but if you work with the test the document, it's breaking down so after I'm so afraid of that all the folks will have the document. At home like that, and then it's really all for the and once you change that particular field, you realize it's going on. We were up there at the tentative for one thing. And it's going to be, what are you talking about? They just don't want to be talking about. And once you change to that, But Holmes' defense, Holmes is not an efficient breach person. Holmes is not saying it is a good thing for someone to breach the contract. He describes it as an option, but the point I'm making here is that the option theory was one of many explanations, and what he was trying to argue was that in the enterprise describing the law, didn't need a more complicated account. And one of those kind of, you go back to the whole letter, one letter is Holmes. Holmes said, well, what about Holmes' answer was, I'm not talking about contract, I'm talking about common law. Yeah. Not as an arrow says. Right. And that's but again, Harriman was completely all over him on that particular point, and rightly so. I think in terms of where, yes. Where I think there's sort of two stories to tell about Holmes. One a little bit more charitable than the other. One is Holmes was infatuated with the fact that he was infatuated with Charles Saunders Peirce, and really thought that he was doing to the law what they were doing to philosophy. And
and that he thought that that's what you should do as a legal scholar. Is you should be someone who looks at the law and tries to figure out. And, right. Yeah, again, it's completely in that spirit. The other take on him is the young astronomer take. You know, this is a man who has serious problems, who can't connect or interact with stuff. His approach to law reflects the fact that he's
the irony for the common people. Something like is the assumption of risk and self-reliance. We write in this book about the evolving at the time when the other issue, the act of very reasonable not to apply to the whole context or overlap in faith. Most of the basic the evolution of concentration on public in that article and then over into the next period. It is odd. No, he was not the contemporary attitude that he thought he was.
relevant data were cases not.
But they were cases by that time. I mean, that's the whole. Before the common funding document, on the question of the assumption of the contemporary writers before the time place. That would be that's all of it.
I don't remember. Yeah, I think check. Yeah, or in Kemp's commentary. Yeah, it's just sometimes. Of course, you can check that now, given that these things are all so thick.
Some of that feminine is modern, incomplete contrast. It's not thinking about it just why or so. Assignment of the primary element is that one of that is.
It's yeah, and again, you also have to ask, how valuable is this particular enterprise of trying to search for fundamental principles? Remember Holmes himself in the common law was skeptical about whether fundamental principles exist, and it may be just a quixotic exercise to sort of think that you can systematize the law at all. And I think we now live in a world where we're much more skeptical about that. I think there are various areas. So I think the value of primary and secondary obligations is not so much it's going to give a robust, coherent, wonderful account of society cases, as does offer ways of pressing and saying, wait, get it right. To give another example, let us say that I promise to mow your lawn on Saturday, you promise to wash my car on Sunday. And it turns out that it's a trivial matter for you to get someone else to mow the lawn. But actually, it's a really big deal for me to get somebody else to wash my car. Okay? If I don't mow your lawn on Saturday, of course, I owe nothing in the way of expectation damages. But that's not the big issue. The big issue, the reason why I'm going to be skeptical about not mowing your lawn is because once I refuse to mow your lawn, you now have the option not to wash my car. So even though in the Holmesian universe, I just had this option, well, it's not really an option because the option I have is conditional upon, is tied up with your own performance. And this idea that, I think this is one of the things that's neglected often in the first year contract. In practice, the biggest thing that happens on breach is not my right to sue for expectation damages, it's the relief I get for my obligation to perform. That really matters on the ground in a huge number of decided cases. you look through your contracts casebook, you'll see large numbers of cases in which both parties are suing each other, and the person who gets to win is the person who breached second. And because they've been released from performance. Okay, that whole dynamic is something that, again, Holmes's theory doesn't capture. And so I think just if you use Harriman just as a thought experiment of saying, wait a second, if we really took this seriously, where else can we find these? And so, just in talking about it, we've come up with quite a few of these instances where what Holmes is doing is not right, even by his own standards. His own standards of coming up with an adequate description of the law, adequate description. Not doing what he set out to do. And that's the way this treatment is a little bit different than this treatment.
The perfect one was this for again, and certainly in the law that there's 41 is basically that can't be confident that your brief is not a good thing, what the other party is active where
Right.
that lack of certainty.
Yeah. Right. Yeah, which is something that the Posner completely neglects in his account of efficient breach, is the possibility of renegotiation. Yeah.
I think the other ability
Right.
I talked about that when I was that.
Oh, that's a great article. Yeah.
And in all of those cases, what happens is that the consequential damage for very radical. And yet without going to either restitution on the one hand or the other. So the whole model of Fuller is in absolutely no sense that in fact he will contact on this issue. One to do the model of earth that one of the probabilities is multiplied by the constant. But it's going to quantify that the number they can actually make this a lot bigger for everybody. However, vast legal consistency has to be exercised because of this notion that it's very much for home. Whether or not you think that the Fuller review stuff actually does create the contract review.
Yeah, well, I've never thought of Fuller and Purdue as being Aristotelian. I've sort of thought of it as, Papa Bear, Mama Bear, Baby Bear. One was too hot, one was too cold, the middle one was relied for just right. And I may like Aristotle, but I wasn't a big fan of Papa Bear, Mama Bear, Baby Bear. But no, I think I think if you want to go all in for, this notion of what are optimal damages, I think it's very hard to defend even expectation damages in the sense that if you really believe it's an option, then what you really have is a problem in option pricing. And we know the problem of option. There's no reason to think the option price would equal expectation damages. Yeah. Yeah, yeah, yeah. As you pointed out in your foreseeability paper.